Copyright in these lectures is either owned by the ANU or a third party who has licensed the ANU to use it. Students may use the recording for personal study only. No lecture may be communicated online, copied or shared without the prior permission of the ANU.
All right, let's make a start. Before I do actually start, so just to be really clear, so tutorials started this morning. Hopefully that's all gone smoothly. I think everyone should be enrolled in a tutorial by now. There was still a couple today that wanted to move and stuff, and I think we've accommodated those. If you're not enrolled in a tutorial, shoot me an email now, or maybe not right now, maybe wait till after the lecture. And I'll accommodate it. So don't stress. Tonight we're going to consider the various corporate forms. We'll look in detail, obviously, at companies. We'll look at some case law that illustrates why, or some of the features of companies. So how the courts have applied some of those principles, and we'll develop some more of those concepts that we started to consider last week. So let's get into it. So the corporate form, the key feature of companies that I wanted to really emphasise tonight is actually the idea of limited liability, which is, and by reason of limited liability, we have this separate legal entity. So what do we mean when we refer to separate legal entity? Precisely what we've set out there on this slide, that there is a distinction between the debts of a company and the debts of the owners of the company. There is a distinction between the assets of the company and the assets of the owners of the company. So there is so really what that's illustrating is that the shareholder is a separate legal entity from the company itself. So you may own a company, you may conduct business through a company, but you'll need to make decisions whether the company owns assets, whether the company borrows money, or whether you personally own the assets or borrow money. One of the things we'll see in these few cases that we'll look at is that a company can enter into contracts with its members, with its shareholders. We'll also see that one individual can interact in a variety of different roles with the company. So we'll see that that one individual can be a shareholder of the company, can be an employee of the company, and can also be a director of the company, can also be a creditor of the company. So that's a really important concept to get our heads around. And it all relates to this separate legal entity. And indeed, there is also this idea that the company can be liable in tort. In law, we use this metaphor of the corporate veil. So this idea of separate legal entity gives rise to this notion of a corporate veil. And last week I introduced the concept of limited liability. If a company owes money, if a company has debts, then it is the company itself that owes the money to its creditors, not the shareholders. And so where creditors, and we'll see this illustrated, where creditors sue the company, they can try to recover funds or assets from the company, but they are prevented from suing shareholders. They are not going to be able to recover from shareholders, with some exceptions. And so the courts use this metaphor, this idea of a corporate veil, so a veil being like a curtain. The courts have said it's almost like we have a company, but then behind the company, between the company and the shareholder, is a corporate veil that you cannot look behind the company. So if you want to sue the company, so if the company is insolvent, what does that mean? So if the company has more debts than assets, what does that mean? It means you can recover whatever you can from the company, but you are not able to recover from the shareholders. Even if the company doesn't have enough money to pay out all of its debts, creditors cannot recover from shareholders. Why? Because of this idea of a corporate veil. Separate legal entity, there's a corporate veil between the company and the shareholders. And this was illustrated in probably the most well-known corporate law case. This case that the case of Salomon and Salomon. I remember studying Salomon and Salomon when I studied corporate law. So it's a late 1800s case. So this principle, separate legal entity, limited liability, and the court rigidly applied the principle of limited liability in this case, and has largely maintained that view over the last 120 plus years now. So Salomon and Salomon is to corporate law what Donoghue and Stevenson is to the law of negligence, right? So this is a fundamental case. If you don't learn anything else for the next semester, learn this case. Salomon and Salomon. Mr. Salomon was in business. He was a boot manufacturer. He made boots. Now, when he started this business, he operated it as a sole trader, so not as a company. Okay, he operated as a sole trader, not as a company. And that just means he hadn't incorporated. What he did, though, is that after a period of time, he decided to effectively operate the business through a company. How did he give effect to that? Well, he created a company and he sold the business to the company. So separate legal entity, the company actually purchased the business off him. How did the company pay Mr. Salomon? Well, the company borrowed money. Who did the company borrow the money off so that it could pay Mr. Salomon? It borrowed the money off Mr. Salomon so that the company could pay Mr. Salomon. And hence why, if we look at this case, you see there I said that Mr Salomon was the major shareholder of the company, he was also the managing director of the company, and he was also a secured creditor. So I've tried to illustrate that in this slide here, that we've got a company here, got Mr Salomon. Mr Salomon sells the business to the company, and the company pays Mr Salomon for the business, because the business is fundamentally just an asset. So it pays Mr Salomon for the business. And as I said, how did it obtain that money? It borrowed the money off Mr Salomon. Hence, Mr Salomon was a creditor of the company, also a shareholder, and we said he was also a director. And we see that there is this corporate veil between the company and Mr Salomon. That's what this red line's illustrating here. Now, when I should just note one other point in the case. When Mr Salomon lent the money to the company, he did so. The company was required to put up security. So this meant that Mr Salomon was not just a typical creditor, he was a secured creditor. Later on in the course we will talk about the difference between secured and unsecured creditors. But for our purposes today, the benefit of being a secured creditor is that the secured creditor gets paid out before all the unsecured creditors. So secured creditors get paid out every cent that is owed to them before unsecured creditors see a cent of the money that's owed. So what happens to Salomon Company Limited? Salomon Company Limited was trading, but it became insolvent. So Salomon Company Limited, whose major shareholder was Mr Salomon, whose managing director was Mr Salomon, and whose creditor was Mr Salomon, secured creditor was Mr Salomon, became insolvent. So when a company is insolvent, that just means that it has, for our purposes, it means that it has more liabilities than assets. It owes more money than it has in assets, which means it's unable to pay all of its debts. So the company is insolvent. Mr Salomon, we said, was a secured creditor, but he wasn't the only creditor of the company. There were other creditors. Mr Salomon, though, was the only secured creditor. The other creditors were unsecured creditors. So what does this mean? This means that when the company became insolvent, the creditors would make a claim against the company. Of all of the creditors, Mr Salomon, as the secured creditor, would get paid out first before the unsecured creditors would see a cent. And that was precisely the way that this was going to work, until the creditors said, hang on. And I think we could all identify that that seems unfair, that Mr Salomon has been the managing director of this company, allowed the company to become insolvent, is going to get paid out first. So the other creditors sued, so they bring the matter to court, and they argued that the credit arrangement between Mr Salomon and the company was a sham, and that the loan was invalid, and that instead Mr Salomon should have been personally liable to them. What does the court find in response? The court upholds the principle of separate legal entity, of limited liability, and says, well, actually, there's a corporate veil there. So when these other creditors sue the company, they say, we're not going to let you, the court said, we will not let you look behind this corporate veil. You will not be able to recover from the shareholder. So this is the first time that the court rigidly applied the view of limited liability. And effectively, the court was saying that Mr Salomon was entitled to be paid out first before all of the other creditors. So the court upheld the principle of separate legal entity, but the shareholder is separate from the company, and the principle of limited liability. There's a couple of other points that the court made, which are probably worth just covering off. To be a secured creditor, the creditor must have registered their interest in a publicly available register, and that is still the case today. So in order to be a secured creditor today, you must register your interest. So there is a public register which you can now search online, and in that you can find out if people owe money, which is subject to a secured creditor arrangement, so that you can identify if someone will get paid out before you. So that was the first thing the court said. Well, it's hard to argue that they were trying to, that Mr. Salomon was trying to deceive you or perpetrate a fraud on you if this was available publicly. So that's worth noting. And the court actually said also that there was no indication of any fraud. So a very significant case, and really clearly illustrates some of those legal principles. Let's move on to another case, the case of Macora and Northern Assurance Company Limited. Mr. Macora owned a timber estate, and he operated a business which was effectively a logging business. So it was a pine plantation. He would grow these trees and then he'd cut them down and sell off the logs, sell the wood. What did he do? He did something very similar to Mr. Salomon. He sold the business to a company of which he was the major shareholder. So he just changed the structure from operating as a sole trader to the corporate form. Slightly different scenario and slightly different issue in Macora's case. With Macora, after he had sold the business to the company, he took out an insurance policy. On his timber plantation, which actually wasn't his, because he'd sold it to the company, which he was the major shareholder. And that was precisely the issue, was that Mr. Macora took out the insurance policy in his own name, not in the name of the company. So what happened is that 16 days later, and you can read into that what you will, but a very short space of time, 16 days after the insurance policy was taken out, a fire destroyed the forest, the timber estate, destroyed the asset. Mr. Macora goes to make a claim against the insurance company. And what does the insurance company say? The insurance company argues separate legal entity against Mr. Macora and says that we have a contract with you as an individual, we do not have a contract with your company. Separate legal entity. The insurance company and the court agreed did not have to pay out the insurance claim to the individual as a separate legal entity. So it upheld this legal principle. So that's quite a narrow interpretation of separate legal entity, and one wonders whether the short space of time might have influenced the judge's decision there. The other aspect to this case is that the law here has shifted a little. So you may recall when you did commercial law, when you studied contracts do you remember a thing, privity of contract? Privity of contract. So privity of contract says that there are two parties to a contract. There's party A and party B, and only party A and party B can enforce that contract, right? So that's the doctrine of privity of contract. So even if there was let's pretend there was a third party that got a benefit by reason of the contract, if they were not actually a party to the contract, they cannot enforce the contract. So that's privity of contract. The problem is privity of contract, there is an exception to that, and the exception is insurance contracts. So you may have considered Trident's case, which is a 1980s case, and Trident's case says, yes, privity of contract applies, but it doesn't apply in insurance cases. So where there is a third party that would get a benefit, such as in this case, the third party can actually enforce the contract. But it is an illustration, this case, Macora, of the separate legal entities case. Separate legal entity, the doctrine of separate legal entity. So let's move on. Let's look at another case. This case is Lee and Lee's air farming case. It is a New Zealand case which went on appeal to the Privy Council, the House of Lords in the UK, at a time where that was the highest court of appeal in Australia, hence it is binding on Australian courts. What did Mr. Lee do? Mr. Lee was a pilot. He flew light aircraft. And it's kind of a sad case. Mr. Lee in particular, we call them in Australia crop dusters. So over large farms, he would fly his little plane over these farms in New Zealand and spray pesticides and herbicides and those sorts of things, maybe fertiliser as well. So that's what he did. It's just that it's a very efficient way of doing that. The problem is it's a little bit dangerous, and that's precisely what happened. Mr. Lee struck some electricity transmission wires. That's one of the biggest hazards in that industry, and he crashed his plane and he died. So it is a sad case. What's the relevance of this case to corporate law is that he, just like Mr. Salomon, just like Mr. Macora, he operated this business as a sole trader, but then he incorporated the business. When he incorporated the business, as I've noted there, Mr. Lee was the major shareholder of the company. He was also the managing director of the company. And that third thing there is the question, was he also an employee of the company? Okay, so Mr. Lee has this company. He said he was a shareholder and the managing director. So he said he died as a result of crashing his aeroplane. His wife, Mrs. Lee, sought to claim a thing called workers' compensation. So workers' compensation, most of you probably know, but workers' compensation, I guess we would say, is a particular type of insurance scheme. It's an insurance scheme that businesses are required to take out for their employees. So if you have a job while you're here, if you work here in Australia, then anyone that employs you, the business that employs you, is required to take out this insurance for employees called workers' compensation. And what that means is precisely that. It covers if you're injured while you're at work, it covers any medical costs, any loss of income, or potentially if you were to die, just like what happened to Mr. Lee. Then any dependents could make a claim, and that's what Mrs. Lee did. So her husband dies, so she makes a claim under the workers' compensation, under this insurance scheme. So there's a little bit of background to this case, but so what does that mean? What's the problem here?
The problem here for Mrs. Lee is that Mr. Lee's, yes, he's a shareholder and yes, he's a director, but directors of companies are not protected by workers' compensation. It only protects employees of companies. So this whole case was about whether an individual could be a director and also be an employee of the company. And interestingly, I said this is a New Zealand case. When the High Court of New Zealand first heard this case, the High Court said no. Said no, you cannot be both a director and an employee. So Mrs. Lee wouldn't have been able to claim workers' compensation. But Mrs. Lee then appealed to the Privy Council in the House of Lords in London, in the UK. And the test that the House of Lords, that the Privy Council applied, was not whether you can be both a director and employee. They accepted that you could be both a director and employee. They said, was the individual doing the work of the company? Was the individual doing the work of the company when they suffered the injury? So in response to that test here, the Privy Council said, well, he was out flying the little aircraft. So yes, he was doing the work, he was doing the business of the company. So the court said at the time that he sustained the injury, he was an employee, he was acting as an employee, and therefore Mrs. Lee was entitled to claim workers' compensation. So with these types of cases, and this is an issue that might come up in this week's tutorial questions, the question is whether the individual is doing the work of the company. And if they are, then they are acting as an employee and they will be able to claim workers' compensation. So in this case illustrates that, yes, an individual could be a shareholder, a director and also an employee, separate legal entity. Okay. So there are some exceptions to the corporate veil. Remember I said there are some exceptions. This slide here just provides a summary of them, so we'll deal with each of those. The first exception is what we would describe as a sham, where an individual has so a sham is where an individual has set up a company really solely for the purpose of avoiding an existing obligation. So the avoidance of a legal obligation. So the case is the Guildford Motor Company and Horn case. Mr. Horn was an individual. He was employed by a car company, a car dealership. As part of his employment, he had a contract, an employment contract that said if you leave the employment of the company, then you are not to go and work for a competitor within a 5-year period. So it's a non-compete clause that carried on for about 5 years. So it's pretty strenuous. I suspect this would not hold up in 2019. I don't think the court would allow that. But the court did in 1933. So he had this non-compete clause. What did he do? So he did leave the company, the employment of the company, and he went and started his own company. And the company that he worked for initially said, you can't do that. And he said, what do you mean? He just said, my employment clause says that I can't go and work for someone else. He said, I'm not working for someone else.
I've just set up my own company. And the original employer sued him for breach of contract. And the court said that Mr. Horn had set up this company solely so that he could avoid a legal obligation that he had not to compete with the original employer. And so the court actually lifted the corporate veil and said you're not allowed to do that. So that was a sham, if you like, where that was being done just to avoid a legal obligation. Now let's have a look at the case of Re Derby. Now I will just draw it up just because the facts may be a little bit confusing. So we've got this company, the Welsh Slate Quarry Company. The directors of this company were Derby and Mr. Guide. They set up this company and they asked for investors. Who did they ask to invest in the company? Just the public at large. So the public are the shareholders in this company. So they had lots of investors who became shareholders of the Welsh Slate Quarry Company. So they paid money into the company, and in return they became, just members of the public became shareholders. So what was the issue in this case was that Derby and Guide had their own company and they had a license to quarry. So it was an asset. So the company Derby and Guide, not this company, just this company had an asset. What Derby and Guide said, well, let's sell this asset, okay? They're selling this asset, and in return, sell something, we'll get the Welsh Slate Quarry Company to pay money. Who does the money goes to? It goes to D&G Company. And who are the shareholders of D&G? Well, it's Derby and Guide. It turned out that this asset was basically worthless. It wasn't worth anything. But the company had paid money for this asset. This company eventually became insolvent. So the shareholders, when they went to say, hey, we've got this asset, and found out it was worthless, what's going on here? And it became obvious that what had happened was that Derby and Guide had set up this company simply to perpetrate a fraud on these shareholders, to get them to pay money, that ultimately that money ended up in the hands of Derby and Guide in return for this asset. So the court looked at this case and said in this case that they would allow creditors, well, they weren't really creditors, they were in the typical sense, but did allow these shareholders to look behind the company, and did actually allow them to sue Derby and Guide. So the court here lifted the corporate veil. Lifted the corporate veil here. Is really where the corporate veil is, because the Derby and Guide company. Yep. So, where there's a fraud involved, the courts may lift the corporate veil, but it has to be a fairly unique situation. You have to really be able to show what is the fraud that's been perpetrated there. Okay, a couple of other little examples that we can talk through. Jones and Lippman. So Jones and Lippman just dealt simply with the sale of land. Lippman sold or entered into a contract to sell the land to Jones. So Jones has paid money to Mr. Lippman, but Mr. Lippman did not then transfer the land to Mr. Jones. What did Mr. Lippman do instead was he set up his own company and he actually transferred the land to a company. So when Mr. Jones sued Mr. Lippman for the land, said, "Oi, I've paid you for that land," he said, "Well, it doesn't belong to me, it now belongs to this other company." Well, the court said, that is, you have created this company to avoid a legal obligation, the legal obligation to comply with the contract that he had agreed to. So that was another example where the courts have lifted the corporate veil. The Daimler case, that Daimler as in the car manufacturer, so that may be familiar to you. This case goes back to World War One. In World War One, because Great Britain was at war with Germany, there was a prohibition that Germans were not allowed to run businesses. They're not allowed to trade in Great Britain. So we've got this car manufacturer, Daimler. So what did they do? They set up a company. They incorporated a company. And this was challenged successfully. And the court lifted the corporate veil and said that you have created a company just to avoid this prohibition on Germans from trading in Great Britain during the war. Yep. So it was another example. So some slightly different ways of looking at that legal principle of the corporate veil. Under the statutes, the corporate veil still applies, and these principles of separate legal entities still apply. But there are some exceptions. The main one in that list is the Section 588G. So Section 588G of the Corporations Act says that directors have a duty to avoid trading whilst insolvent. If they breach their duty, then they will be personally liable. So it is a way that directors will actually be liable for debts that they incur, in a particular scenario. All right, a couple of other statutes that just talk about, a couple of other sections of the Act that talk about how separate legal entity is applied or is enforced or comes into existence under the Corporations Act. So Section 119A, company comes into existence on registration with ASIC. Section 124 is a provision that we will revisit on a couple of occasions in this course. Quite a significant section in its own right, and it says that a company has has the legal capacity and the powers of an individual. Yeah, so companies can do anything that natural persons can do. Companies can do anything that natural persons can do, with some exceptions, So I sort of say, look, except where that would be silly. We'll talk about some exceptions as we go through the course. And yeah, Section 114 just recognises that we can have one-person companies. So some things to think about as we go through the rest of the lecture. I'm going to talk about some of the features of companies. So we talked in a couple of those cases about individuals who have run
their business as sole traders. So a sole trader is a business form which is not a company, so it's where they have not incorporated. So sole traders do not have limited liability, whereas companies do. But a lot of businesses start out life as sole traders, and often a question that you'll be asked to consider in practice is whether you should incorporate. So that's what this slide is just setting out. Some of the things that you should consider. If someone says, hey, I've got this business, what do you think? Should I incorporate? Should I change from a sole trader to a company? Yeah. So what are the things we're going to think about? Some of the things we'll think about are, and we'll explore these further, whether it is a for-profit company or for-profit business or a not-for-profit business. We need to think about whether limited liability is attractive. And remember what I said last week is that limited liability is probably the most important feature of companies and would be the biggest driver. The biggest reason that you would incorporate, I suspect, would be limited liability. It's why there are so many businesses incorporating today. Think about how big the company is going to be, not just in revenue, but how many owners of the business, how many people will be involved with the business. So that's why I say limit on size. The ability to raise capital, is that going to be an important issue for you? So companies have the best ability to raise capital. So if we would compare the corporate form to other forms, companies are able to raise capital by selling shares. I guess there's a trade-off though with incorporating, is that there are administration expenses with incorporating. There are forms you've got to fill out. You actually have to go through the process of registering. You have to talk to ASIC every year, not just the Australian Taxation Office. So there are a number of things that companies have to do. So I would say we sort of have to say, look, there's a lot of benefits to incorporating, but let's not pretend these other things don't exist. So administration is, I guess, the biggest reason some people decide not to incorporate. Yeah, so that's what we're talking there about, formalities and expense, audit and reporting requirements. The last one there is the tax treatment. Now, this is always a little bit controversial when I talk about tax treatment. So, and it's become more of an issue actually in Australia this semester than in previous semesters, because the opposition has expressed that they would like to overhaul the tax treatment of companies, but in particular a thing called dividend imputation in Australia. So, how are we going to talk? I'll spend a couple of minutes just talking about tax treatment. So, this is not a tax law course. Some of you may do that later, some of you may be doing it now, which is possible. Busy, but possible. So, tax treatment. The point that I want to make as far as tax treatment goes for this course is I would just say companies are taxed differently to other business structures. So companies are taxed differently to sole traders, partnerships, and in fact trusts, although if we're going to go down the path of setting up a trust, you'd be silly not to set up a corporate trustee, which means that you are actually still going to be hitting the same corporate tax. Okay. So let me just talk for a little about the law as it stands at the moment, bearing in mind that there is an election not too far away, and one of the parties has said this is one aspect that they propose to change. So, I've said that companies are taxed differently to other structures. Remember when I started talking about this slide, I said if someone came to you and said, hey, I'm thinking about incorporating this business, what do you think? As far as tax goes, I would say tax should not, for our purposes, for this course, be a reason to incorporate. So I would not go out and say, look, companies have a different tax rate to individual marginal tax rates. Okay, so let's just talk through that issue. So companies, there's a couple of different rates, but I'll keep it a little bit simple. I can talk in detail in private, but companies, the corporate tax rate in Australia is 30%. It is effectively a flat tax rate. It's actually slightly less for small companies, but let's just ignore that because it doesn't actually change our consideration. Corporate tax rate is 30%. What are the marginal tax rates in Australia? Well, they vary. Anything from 0, depending on how much money you earn, and they go right up to 48.5%. Right? 48.5% versus 30%. So, does that mean that if you're a high income earner, that you would be better off incorporating your business? The answer to that, I would say, is no. Why not? Because the way that the tax office would treat you is to say, you've earned money through the company, and the biggest difference I should mention before we go on is that companies pay tax themselves. The company itself pays tax. If you set up as a sole trader or a partnership, the sole trader or the partnership do not pay tax. The income flows straight through the sole trader, straight through the partnership, and the sole trader personally or the partners personally pay tax. Okay? Whereas when revenues come into a company, the company pays tax on its profits, and the after-tax profits are then distributed to individuals, to the shareholder, to the individual shareholders. Okay, what happens to companies, or what happens to the individuals when they receive money from a company? Do they pay tax on the dividends of companies? Well, the answer to that is yes, they do. Does that mean that double taxation applies? Because the company pays tax and then the individual pays tax. That sounds a bit like double taxation, but it's not. There is no such thing as double taxation as the law currently stands, because the individual, when they go to pay tax, the tax office says, oh, the company has already paid tax on that money. So we give you a credit. We'll give you a credit for the tax that the company has already paid. Okay? So there's no such thing as double taxation. Does that mean companies pay lower tax? Well, they do, but the tax office only gives you a credit for how much tax the company has already paid. So if we think about that scenario where the company has paid 30%, if you're a high income earner in Australia, you should have paid 48.5%. The tax office says, all right, the company's already paid the first 30%, but that extra 18.5 cents in the dollar, you still have to pay us that money, okay? Now, what does that mean? That means whether you set up your whether you set up your business as a company or as a sole trader, you're still paying 48.5 cents tax rate. So it makes no difference whether you set up as a sole trader or you set up as a company. So the tax effect, the tax argument does not apply. And I'll go one step further, and again, this part of it is the controversial part in Australia at the moment, is that if you are a low-income earner in Australia, let's say that the only money that you earn in a year is dividends from a company, your marginal tax rate should be 0, right? You shouldn't pay any tax as a low-income earner. But you receive this money from a company by way of dividends. The company's paid 30% tax on that money. So the way the law works currently is that you can then go to the tax office and say, well, I've received this money. The company's paid 30% tax on it, but I shouldn't have to pay any tax. The way the law works at the moment is the tax office says, well, the tax office will actually write you a cheque and give you cash and say, well, if you just received that money as a sole trader, you wouldn't have paid any tax. So it's actually symmetrical. It works both ways. So if you're a low-income earner who just earned that money, or received that money as a sole trader rather than through the company, you would pay 0 tax. And similarly, the way that dividend imputation works in Australia, you would not pay any tax on that money either. You would actually, whatever tax that the company's paid, you receive a credit for that. So that's when you hear the phrase dividend imputation scheme in Australia, that is what we are referring to. The fact that you get a credit for tax that a company has already paid. So in the report question, which I'll be posting to Waddle shortly, one of the issues might be, should I incorporate my business or should I run as a sole trader? If I see anyone say something like there's double taxation or the tax treatment of companies is better, I'll put a big red line through it, okay? Because of dividend imputation, all that you need to say really is that companies themselves pay tax, but there is no financial benefit for our purposes in setting up, as far as tax goes, in setting up as a company versus a sole trader. Now, look, it's not a tax law case, of course, so I will say there are things that companies potentially could do. The most obvious thing that companies can do is to retain earnings. So if you, as a high income earner, knew that in future years you were going to have a low income year, then I guess that would result in a different tax outcome. Because the company can retain earnings this year and you say, well, I won't be paid out this year, I will receive dividends in a future year when I know I'm going to have a low income year. So there are some things, but I think that's beyond the scope of this course. For our purposes, what I've just outlined in relation to tax treatment was really, I think, all that we need to know. The companies are taxed differently. Okay. Now this slide largely reiterates a couple of things that I should just mention. So by comparison to sole traders and partnerships, companies have an advantage in that partnerships are limited to no more than 20 partners unless they are exempt. So law firms and accounting firms are an exemption. But for just ordinary businesses, they are limited to no more than 20 partners, whereas companies, depends on which type of company, there is no limit on the ownership of the company.
We've talked a little bit about limited liability. I'll revisit the excuse me. I'll revisit limited liability in a moment. We've said different tax treatment. I'll cover off those last 2 points shortly. The disadvantages, and I was getting a little bit ahead of myself. The disadvantages are the administration. The other one, actually, the other point that I skipped over is the publicity effect. So when you are companies that are incorporated must report to ASIC, and there is then information about the company which does become public. So ASIC publishes, and you can do an ASIC search to find out information. A lot of investigative journalists use this to try and get their head around what's going on with some companies. So you can do an ASIC search to obtain some of the details about companies. So place of, registered place of business, directorships, shareholders, those sorts of things are public. And then it depends on whether we're dealing with a private or a public company as to what other information. But that information is all publicly available. But the decision about whether to incorporate or not, as I've said there, depends on the individual circumstances of the business. Now, I'm just wondering if maybe that's a good place to pause. If I pause there, so I will resume talking, looking at the clock on the back wall there, which is a little bit slow, but I'll resume talking at 5:05 according to the clock on the back of the wall. All right, guys, let's keep going as I... All right, let's keep going. One thing I wanted to do is just to show. I've left it up in the office, the textbook. So sorry about that, but yes, in case you haven't seen it already, that is the textbook for the semester. So have a look at that. Remember what I said, that for tutorials. So this week, for this week's tutorials, I've posted the questions to Wattle, but just remember that for next week, the questions come from the textbook, and it's from chapter 26. So have a look at chapter 26 for the questions. Something else? Oh, there was one here. Is that I posted the schedule of questions as well. So if you have a look on the Wattle site, you'll see the actual schedule of questions. So which questions from the book we are doing each week. That's what I have posted. Okay. So before the break, I was talking about some of the features of companies. Now we're going to look at some of the types of companies. Now we opened this conversation last week, I guess, at a bit of a higher level. So what are the different types of companies? So the two main types of companies are public and proprietary. So all companies must be either proprietary or public. Section 9 defines public company as any company which is not a private company. So we've got two, that's the main distinction. We've got two main types, different types. We can break it down further, but we have public companies, we have proprietary companies. Within that, we have a few other categories or classes. So we also have limited liability companies and unlimited liability companies. So last week I talked about limited liability companies, but perhaps we'll do a recap and it might be helpful then to explain what we mean when we say no liability company. So remember, limited liability company, if I start up a company and say I'll buy or start out with 1,000 shares in the company and I pay $1 for each share in the company, 1,000 shares, so 1,000 times $1 is $1,000. So that is my investment. That is the extent of my liability, that $1,000. So when we say limited liability, that is what we mean. My liability is limited to that $1,000 which I have already invested into the company. That is limited liability. If the company becomes insolvent, as we saw in Salomon and Salomon tonight, and the creditors sue the company, they can sue the company even after they have taken every cent out of the company. They cannot sue me as a shareholder of the company because of the corporate veil. My liability is limited. They will get that $1,000 that I had already invested in the company, but that is all that they will get. Okay, so that's limited liability. So the next one is limited by guarantee. That is a very unique scenario. It's used in particular for things like independent schools, where the shareholders don't actually contribute money, but they provide a guarantee up to a certain amount. That's pretty rare, and we won't deal with that particular type of company again for the rest of the semester. That's it. Unlimited liability. So you can still have unlimited liability companies. And so that simply means that if the company becomes insolvent, the creditors could sue the shareholders. Yeah. Now, I guess one point to note is that, I think we touched on it last week, but I'll say it again, limited liability companies, the company must include
the word limited in its name. Okay? So nowadays we do assume that when we're dealing with a company, it is a limited liability company, but the old rule that you must include the term limited or LTD in the company still applies. If it includes proprietary limited, then we know that it's a proprietary company, or the PTY. It must be a proprietary company. All right, so that's limited liability and unlimited liability. What is a no liability company? No liability company. So this is it's actually very similar to a limited liability company. And in fact, to illustrate it, I'll go back to our limited liability company. So let's pretend, sound like a kindergarten teacher. Let's pretend with our limited liability company that I say I'm going to start out, invest 1,000 shares. I'm going to buy 1,000 shares. If I say to you, if I say when I set up the company, I will pay $1 today for each share that I have in the company, and in 12 months' time, I will pay another $1 for each share that I hold in the company. So this is what we call partly paid shares. It is actually quite common that if I say I'll invest $1 today and in 12 months' time I'll invest another $1. 1,000 shares, so I'm obligated to pay $1,000 today, and I am also obliged to pay a further $1,000 in 12 months' time. Now, if this was a limited liability company, my liability is limited. What's it limited to? Well, it's limited to the $1,000 today plus the $1,000 in 12 months' time. So, in theory, my liability is limited to $2,000. Okay? All right. What happens if the company becomes insolvent? If the company becomes insolvent, I've paid my $1,000 today, but the company can also compel me. They can sue me at contract law to pay that extra $1,000. So in this example, my liability has just extended a tiny little bit. My liability has extended that extra $1,000. But that is all. My liability is limited to what I have agreed that I will pay. So a no liability company relates to that example. So a no liability company, and you will see if you look at the Australian Stock Exchange, if you look at the, in the old days when they used to publish every day, I think they still do, there used to be the All Ordinaries section, and then there used to be the mining section, so the mining shares. A lot of the mining shares used to have a little abbreviation after them said NL, and that NL stood for no liability. So what is a no liability company, and why does it only apply to mining? So no liability companies, remember that example with our partly paid shares. If I say I will pay $1 today for every share I have, and in 12 months' time I'll pay another $1. With the no liability company, I have to pay my $1,000 today, but the company cannot force me, they cannot sue me for that extra $1 in 12 months' time. So that's where I say no liability companies are actually more similar to limited liability companies. Okay, so let's tease out that example a little bit. So I'll pay my $1 today, or my $1,000, $1 for every share today, $1,000 today. No liability company, I can decide in 12 months' time, actually, I don't like this company anymore. I don't think this company is going to make money. I feel like if I give this company any more money, I'm just wasting my money. All right, so I can make a decision not to pay that extra $1 in 12 months' time. What happens if I do that? If I do that, I forfeit my shares. I give up my shares. So the company will actually cancel my shareholding. So that's the no liability issue. So yes, I've said I'll pay it, but I've also said I'll consider the issue in 12 months' time. So that's a no liability. Even if the company was to become insolvent, the company cannot force me or compel me under contract law to pay that extra dollar in 12 months' time. But if I choose not to pay that extra $1, then my shares will be cancelled. So I've lost my initial investment. Yeah. Now, what else we know about no liability companies is the Corporations Act limits their use. They can only be used by mining companies, Australian mining companies. So companies set up in Australia for the purpose of mining and exploration is the only time they can be used. And if you think about it, in a way, it kind of makes sense that that's probably the only scenario that would actually make sense. That I say, look, I'll invest a little bit today. If the company in the first year strikes gold, iron ore or oil or whatever it is they're looking for, then yes, I would probably think it's a good idea. But if they don't find what they're looking for in that first year, then I'm not likely to pay that extra money, and I'll just forfeit my shares. Okay. And look, proprietary, whether public proprietary, limited or unlimited liability, mean exactly the same thing. So I'm not going to say that twice. Yep. A couple of other ways we can cut these companies. So public companies, we can have listed or unlisted companies. So I think this will come up in tutorials next week. That not all public companies are listed public companies. So typically when we hear that term public company, typically we think of listed companies. What do I mean by listed? I mean companies that are listed for quotation on a secondary market. So usually what we mean there is listed on the Australian Stock Exchange. But not all public companies are listed on the Australian Stock Exchange. You can have an unlisted public company. We'll explore that in a little bit more detail. For proprietary companies, the difference is not quite as significant. We have small proprietary and large proprietary companies, but the difference between small and large proprietary companies comes from Section 45A of the Corporations Act. And there is a test there. There's 3 elements to the test. You can look this up. You have to satisfy 2 of the 3 elements. So they look at gross operating revenue of $25 million. They also look at gross assets of $12.5 million. And the last threshold is employees, 50 employees. So if you exceed 2 of those 3 thresholds, then you'll be a public company. But if you only exceed 1 or none of those 3 thresholds, then you'll be a small proprietary company. Now, I guess I'll just make a point here that there's not really much benefit in being a small proprietary versus a large proprietary company. You either are or you aren't. So if someone was to say, should I become or what type of company should I become, you would not say, oh, it's better to be a small proprietary company than a large proprietary company. In fact, it's probably better to be a large proprietary company. There are some large proprietary companies do have some additional reporting requirements, which we'll talk about when we get to reporting requirements. But in my view, if you're a large proprietary company, it's generally because you're more profitable and your company is bigger. So I wouldn't say something like, oh, you're better off being small proprietary because you have less reporting obligations. It's actually better to be probably a more profitable company. Okay, some of the advantages of proprietary versus public. So proprietary companies only have to have 1 director. Public companies have to have a minimum of 3 directors. Of those 3 directors, at least 2 must ordinarily reside in Australia. Proprietary companies do not need to hold an annual general meeting, and they have this informal process for passing resolutions. There are these restrictions on appointing directors, which are set out there. So directors of public companies must be individually voted onto the board, and the directors of public companies must be able to be removed by resolution of shareholders. We're also going to talk about dealing with conflicts of interest. It's one of the few areas of the law where the law is quite different depending on whether you're a proprietary company or a public company. So section 191, which we will deal with in detail, is an obligation to disclose conflicts of interest. If a director has a conflict of interest, then the question is, can they participate in board meetings? And the answer to that is, for proprietary companies, is provided they've disclosed the conflict of interest, then yes, they can. But for public companies, if they have a conflict of interest, they are not allowed to participate in board meetings where they have a conflict of interest. They're not even allowed to be present in the room where a conflict of interest, a matter that they have a conflict of interest in, is being discussed. But we'll revisit that issue. Suffice to say, for our purposes, proprietary, there are advantages of being proprietary. There are also advantages with being public. The biggest advantage of being public is you have the greatest ability to raise capital. Public companies have the greatest ability to raise capital. We'll revisit that issue. Now, just before we move on, I'll put this slide here to say about what section we've said about limited liability. Just remember, don't get too carried away. I think I made the point last week, I'll make it again. With limited liability, that if the company was to borrow money, so you set up a company, you borrow money, go and borrow $1 million, and then wind up the company, take the $1 million and run, is to remember that there are practical considerations, and banks generally don't just lend millions of dollars to small companies that have no assets. So banks, one of the things they will usually do, and they're specifically allowed to do, is to seek a personal guarantee from the company directors. And a personal guarantee, if you think about it, is a way around the corporate veil. Yeah. So if you've got a shareholder who is also a director of a company and they borrow money from a bank or from a finance company, ordinarily what we've said up until now is, there's a corporate veil there. The creditor can't look behind the company. One way to get around the corporate veil is to get the shareholder to put up a personal guarantee. Yes. So just to keep in mind that practical consideration. Okay, I think we've probably covered off on that slide. So let's move on to corporate groups. So we'll spend a little bit of time dealing with corporate groups. I did a check again tonight just to make sure it hasn't changed. The term corporate group, the phrase corporate group, does not apply anywhere in the Corporations Act. So it's a term that we have invented. That said, the Corporations Act does actually describe certain situations, certain scenarios that would give rise to a corporate group. So one of the things as we look through the course, we'll see that this is quite common. That often business structures include a company, but often they actually include several companies that are all related to each other. So we'll talk about how those relationships might occur. And I should mention there are some reasons, some advantages in setting up your business this way. Why would you create lots of companies or more than one company? Why would you create more than one company for your business? Well,
remember this, again, why would you incorporate in the first place? Limited liability. It's a good way to quarantine risk. So if you've got a really successful business and you want to go into a slightly different area and you feel like it might be a little bit more risky, let's set up a separate company for this business which is perceived as a little bit more risky. And then we've got a corporate veil that exists between this risky business and our more secure business. Yeah. So that's one thing. If you've just got different businesses within a group, it's a good way to do it. There's a variety of reasons, but there are also disadvantages. The biggest disadvantage that we see in this course is it leads to things like conflicts of interest, and in particular this idea that if you are a director of a subsidiary company, who do you owe your duties to? Do you need to act in the interests of the subsidiary, or do you need to act in the interests of the holding company or some other company in the group? And the answer, a starting point of answering that question is to say directors owe their duties to the company that they are a director of. So if you're a director of a subsidiary, you owe your duties to the subsidiary, not to the holding company, unless an exception applies. And there's one main exception that comes from section 187 that says that directors of subsidiaries may act in the interests of the holding company, but you have to satisfy the elements there. Moving on. So corporate groups, there's two main ways that will give rise to a corporate group. So there's the holding and subsidiary relationship, and there's also the controlled entities test. And what I'm actually going to do is we'll talk through section 46, but I should also, because it's fallen off our little slide pack there, so I'm not sure why that's happened, but it's not a bad idea every now and again for me to go to the legislation and just show you what I'm talking about. So there's two main ways that will give rise to a corporate group. One is the holding subsidiary relationship. The other is the controlled entities. So we'll look at controlled entities in a second. Firstly, let's do it now. Okay, controlled entities. What is a controlled entity? Section 50AA tells us that an entity controls a second entity if the first entity has the capacity to determine the outcomes of decisions about the second entity's financial and operating policies. So it's really the last part of that subsection there. Does one entity have the capacity to determine the outcome of decisions about the second entity's financial and operating policies? Now, usually when we're thinking control, usually we're thinking if someone has more than 50% of the shares, all right? But that's not actually what the test is for controlled entities. It is the test for the holding and subsidiary relationship, which we'll talk about in a moment. But the test for controlled entities just says, do you control or have the capacity to determine the outcome of decisions about financial operating policies? If you have more than 50% of the shares, then yes, you most likely do control. Most likely you do control the other entity. But what 50AA actually contemplates is that control might come about through other means. Okay, so it might be that you have control over another entity which has a large number of shares in the company that we're talking about. So let's just keep that. And I should mention actually before we move on. So we looked at subsection 1. Subsection 2 operates almost like a test. So when will we know that one company has the capacity to determine the outcome of decisions? Well, let's look at subsection 2. We look at the practical influence that they can exert, and we look at the pattern of behaviour.
such that if one entity was to vote the same way at shareholders' meetings and they always carry the day, then that would be a very strong argument for a pattern of behaviour. So that's the control test. The test we'll look at now is the holding subsidiary test. The holding subsidiary test is a little bit more mathematical, I guess, whereas the other one is more qualitative rather than quantitative. So the holding subsidiary test, there's four elements to the holding subsidiary test. In fact, they're kind of like 4 mini tests, because you only have to satisfy one of the 4 tests. If you satisfy any one of the 4 tests, then it will be deemed to be a holding subsidiary relationship. Now, we'll see there's quite a lot of overlap between the 4 tests. So the first test is whether the holding company controls the composition of the subsidiary's board of directors. How do you control the composition of the board of directors? If you have more than 50% of the shares. So what are the second and third tests? Second test is, does the holding company control more than half of the voting power of the subsidiary? And the third test there is, does the holding company hold more than half of the share capital in the subsidiary? Yeah. So there's a lot of overlap between those first 3 little tests, if you like. And all of them, if you have more than half of the shares, you'll satisfy the test. I will just emphasise the key is more than, I guess in theory, if you have 50% exactly, you may not have a holding subsidiary relationship, especially if there are only 2 shareholders. If you've got 50%, the other shareholder has 50%, then we need to write some rules into the Constitution as to who has ultimate control. The fourth one sort of sits on its own. It's the subsidiary of another subsidiary test. So if we think of a bit of a group of companies, we've got a holding company, and we've got a subsidiary of the holding company. That subsidiary company may have its own subsidiary company. Okay, so shall I draw this up on the board, because I'm getting it's confusing me talking about it. So let's just draw this up. What are we saying there? So with that fourth test there, if the holding company has 100% of the shares in the subsidiary, then we've got a holding subsidiary relationship under probably the first, second and third tests. What about if subsidiary 1 has 100% of the shares in subsidiary 2? Well, we know this. We know that this subsidiary 1 would actually be the holding company for subsidiary 2. But what's the relationship between subsidiary 2 and the holding company? Well, this is a subsidiary of another subsidiary. Therefore, there's a holding subsidiary relationship between those 2 companies as well. Now, while I'm drawing pictures of the board, it's probably worth just noting a lot of times we will, throughout the course, refer to holding subsidiary relationship. There are times where the fact that there is a holding subsidiary relationship, special rules will apply, or you can do certain things. We'll talk about them as we go through. A lot of times, though, I would emphasise, because some students seem to overthink that, is to just remember what's going on in this scenario, is that the holding company here is what? It's actually just a shareholder in the subsidiary. So all the rights that shareholders get, this holding company gets. It is a shareholder in subsidiary 1. And similarly, subsidiary 1 has 100% of the shares in subsidiary 2. So it is a shareholder of this company. So what does that mean? So for example, for our purposes today, there's corporate veils there. Okay. There is a limited liability between the holding and the subsidiary company. Remember what I talked about earlier, why you might set up as a corporate group? Well, it's a good way to quarantine your risk because shareholders are not liable for the debts of the company that they are a shareholder of. Except, with one except, well, actually there's probably a couple of exceptions. Everything what we said tonight about frauds and shams. If you can show under section 588V, if you can show that the holding company, that the board of the holding company knew that the subsidiary was insolvent and continued to trade, then the holding company will be liable for the debts of the subsidiary. And there's another scenario that we'll talk about in coming weeks, which is shadow directors. There's one really good example where the holding company, or a large, actually it wasn't a holding company, it was a large shareholder, which was a company, was found to be operating as a shadow director. But our main issue is section 588V. So just keep that in mind before we overcomplicate these things. All right. Disadvantages. So we talked about holding subsidiary. We talked about the controlled entities. Remember, the holding subsidiary test and the controlled entities test are two different things. Just really keep that in mind, okay? The holding subsidiary is very much a mathematical, does one company have more than 50% of the shares? The controlled entities test is, do they have the capacity to determine the outcome of financial or operating policies? So just make sure that we're aware of what it is that they're asking us for. So just some disadvantages of corporate groups. It's this administration issue that frequently comes up. So in the Walker and Wimborne case, which we'll revisit, the directors there wrongly mix funds amongst the different companies within the group. In the industrial equity case, the directors wrongly pay dividends to the holding shareholders, and in the Quintex case, the bank withdrew money from the wrong company's accounts. The Equity Corp case, so looking at the advantages here, and we'll revisit Equity Corp in a couple of different cases, in a couple of different scenarios. A fairly large corporate collapse, which unfortunately, depending on what way you look at it, is good for corporate law. In this case, the court actually considered there are scenarios where directors of the subsidiary can act in the interests of the holding company, which I alluded to earlier. All right, the next couple of slides, I don't think we need to go into the Quintex case in too much detail, and I'm conscious of the time. So I did refer to section 588V already. So the holding company will be liable for the debts of the subsidiary, but the key is you must show, and there's not a lot of case law to illustrate this, that the directors of the holding company knew that the subsidiary was trading insolvent. And we'll revisit the insolvent trading issue and step through it in a bit more detail. Where you do have a group of companies that is insolvent and being wound up, the liquidator is entitled to treat the assets of the group as a combined entity if it's the group that actually is insolvent. All right, how are we going for time? So there we go, we'll push on. So how are companies created? Companies are created by being registered by ASIC. This is largely done online now, so we'll briefly consider the process for listing. So the contents contents of the registration application, as I've set out there,
you must... Oh, actually, sorry, I'll skip a slide. Yeah. So, yes, how do you lodge your application? Two alternatives. One is you can do the form on the ASIC website. The other is that you register under ASIC's electronic company registration scheme. What do you need to tell ASIC when you register a company? You must tell ASIC the type of company, so proprietary or public, and the class of company. So is it a company limited by shares, an unlimited company, or a no liability company? You also need to include the company name. So remember, we've already talked about there are some rules about the company's name. You also need to say whether the company will adopt a constitution or not. We'll talk about constitutions in coming weeks. You also need to set out the name, address of shareholders, directors and the company secretary, as well as the address of the registered office and the principal place of business. And remember what I said earlier, that a lot of this information can be disclosed publicly. So that is, I guess, a trade-off there to think about whether you want to incorporate. Okay, what else do you need to include? Details of shareholdings and whether shareholdings have been fully paid or whether it's a partly paid scenario. Details of the applicant for registration, so who it is that's actually making the application. The third dot point there is interesting. You need to say which state or territory the company is taken to be registered. There are a couple of reasons for this. Remember last week we talked about which or who has the power to legislate for companies. So, and we said that actually the Constitution does not give that power to the Commonwealth Parliament, but the states have given that power to the Commonwealth. In the event, but remember we said it's only a temporary solution, so in the event that the Commonwealth, the states decide not to give that power to the Commonwealth, then in theory we would go back to the old scenario, which is that the states, territories have the power to legislate. So what does that mean? Well, the impacts here. If when a company registers, it can't just say, well, we're registering in Australia. They need to say we're registering in a particular state or territory for that reason. The other reason why it's important to say which state or territory is we need to say which laws apply, because remember we also use scenarios to say, well, there are industrial relations laws, there are environmental laws that apply in some states or territory that the states have the power to legislate for. So we need to know which laws are going to apply. So that's why you still have to say which state or territory you're registering in, and whether there is an ultimate holding company. Okay, when you do register a company, there'll be someone who's referred to as a promoter. The promoters have duties to act in good faith and in the interests of the companies, and that was actually considered in the Australian Breeders Co-op and Jones case. I won't go through all the facts. The key to this case is that Mr Dunn was King's accountant and a promoter of the scheme, and he set up the structure. So it's just an illustration of a conflict of interest, but we will actually revisit that issue. So the last thing we wanted to do tonight is just to talk through some of these business structures. Conscious we are getting very close on time. So tonight I've referred in passing to a few different business structures. For our purpose, we are studying corporate law, so most of our course we are going to talk about companies, but to be aware that there are these other structures, so sole traders, partnerships, joint ventures, trusts, and associations. So let's just, and it's helpful to just have an understanding of them really so we can understand what the advantages or disadvantages of companies are. So sole trader is where an individual goes and sets up a business and operates their business. that way. A sole trader can enter into legally binding contracts, but remember that sole traders have unlimited liability. So the biggest issue here, unlimited liability. Sole traders are subject to tax and fair trading laws. The sole trader, as I've noted there, owns and controls the business. Remember what I said, liability is unlimited. The next big issue for sole traders is their ability to raise capital is quite limited. So what ability do they have to raise capital? They can go and borrow money, or they can use, raid the piggy bank sort of thing. So they're quite limited there. The benefit, I guess, of a sole trader is minimal administration. So you could go and start up business tomorrow and operate your business as a sole trader. There is nothing really formal that you have to do to go and to actually start business. Whereas a company, as we saw a moment ago, you have to register. You have to register your company. So let's look at a partnership. Look, similar sort of features, but a couple of things slightly different. So a partnership is something that it's an entity which exists between persons with a view to profit. A view to profit. So that's a fairly significant issue. There is some case law there. There is the Partnership Act. You should, if I was advising someone, normally I would say you should actually have an agreement which sets out the terms of the partnership, so a partnership deed. But it is possible to just have this as an implied thing. So you don't actually have to set up a deed or a contract between partners when it comes tax time. And look, this is very common, again, talking about political issues tonight, with negative gearing. Husband and wife or two partners may own a house which they rent out and claim the benefits of negative gearing. When they do that, when it comes time to do their tax, they'll do their tax return generally as a partnership, but they don't actually sit down, and most of the time, they don't sit down and write up a contract between the two of them, but they are actually operating as a partnership. Sort of covered off that. Just with partnerships, so as far as those, I keep talking about three key issues. Partnership has unlimited liability. They have a slightly better ability to raise capital than sole traders, but they are not able to sell shares. So we would say that companies have a better ability to raise capital. The third thing, though, is the administration. As you've seen, is still not much administration. So the advantage of forming partnership is that administration issue is quite low still. A couple of other things we need to note. So there is a thing called a limited partnership. Okay, just be very wary of a limited partnership, because not every partner gets the benefit of, so limited as in limited liability. Not every partner gets the benefit of limited liability. So the managing partner has unlimited liability. So if you were considering whether to set up a business structure, someone asks you that, I would say a limited partnership is a very bad idea, because you do not get limited liability for everyone. So there is someone who's left with unlimited liability. The other thing about partnerships is they have joint and several liability, which is that one partner will be liable for the debts of the other partner that they're incurred in the business. So if one of the partners decides that it would be really important and necessary for the business for them to drive a Maserati or a Porsche or a Lamborghini, then the other partners will actually be liable for those debts. So that's what we mean when we say joint